enough in my view. So today's topic is making an effective PIA request. We can go to the next slide. And your presenters are myself and Sarah Clem. Sarah works both with my office and the PIA Compliance Board. Spencer, as you may know, is our administrator for both programs and is the main point of contact, first point of contact for lots of folks who work with us. In this presentation and discussion, we're going to review some PIA basics. I think many of you are already familiar with a lot of these, with the basic terminology and mechanics of the Act, but I want to set the stage for talking about what makes for an effective PIA request and conversely what doesn't. In order to do that, you have to know something about how the PIA works. We'll go over some tips and ideas to share and discuss. Sarah will lead us through a discussion of exemptions, fees, and timeframes, so you have a little further detail for this discussion. We will wrap it up with a discussion of kind of a summation of do's and don'ts, identify some resources for you, and give you a brief update on what's going on in the Ombudsman program, which we're very excited to do. Okay, so this is the back to basics part. I always like to start at the very beginning, which is that the Public Information Act is a statute enacted by the General Assembly originally back in 1970. So it's been on the books quite a while. For anyone who ever wants to read the text of the statute or parts of it, which are found in the General Provisions article of the Maryland Code, there is an easy way to access it online, and that is through the PIA manual's Appendix E. E is in Edward, and that manual in its entirety can be accessed from the website of the Office of Attorney General, or by clicking on the link when you get this slide. So some of the kind of governing principles that run throughout the Act. Its structure is such that it provides a general right of access to records, and then provides that if something qualifies as a public record to which the Act applies, the requester is entitled to it unless something else in the law makes it exempt from disclosure, and we'll talk more about that. But that's the overall structure of the Act. It's disclosable unless something in the law says otherwise. Now, when we talk about being disclosable, we're really talking about two distinct rights. One is a right of inspection, which the Act provides. It provides for actual physical inspection of a record upon reasonable notice and at reasonable times. And it also provides a right to obtain copies of public records. So those are two distinct ways of accessing public records that are provided for in the Act. Generally speaking, but not always, but generally speaking, the purpose of the request is not going to make a difference to the outcome, meaning whether it's disclosable or not. And that is not true 100% of the time, but it's a good rule of thumb. The Act also directs agencies to err on the side of disclosure whenever possible. So, for example, if only part of a record is exempt, then an agency is still required, may still be required to provide the rest of the record. The Act applies to state and local governments throughout Maryland. It applies to both the executive and legislative branch. It applies to a class of entities that are referred to as here as quasi-public entities or instrumentalities of government. So there are various entities that probably qualify as instrumentalities. There's a multi-factor test to determine whether the instrumentalities provision applies, but things like bi-county, tri-county commissions, official governmental commissions, special taxing districts, and other entities that are typically created by law and in which the government has some authority over, if not right of control. Importantly, the judicial branch of our state government is not subject to the Public Information Act at all. The courts have created their own process for accessing records in the possession of the judiciary, including their own process for resolving disputes about access to records. So my office has nothing to do with access to judicial records, but the judiciary has a process that you can utilize if you seek those kinds of records. So this is kind of an all-important definition in the Act, and that is because the Act provides, as I mentioned, a process for accessing public records. It only applies to public records. If something is not a public record, the Act has nothing to say about it whatsoever. It's beyond the reach of the Act. But a public record, as defined in the statute at 4101K, is a very broad concept. It includes any documentary material that is either made or received by the agency in connection with the transaction of public business in any form. So that means, generally speaking, that any record, regardless of the format or form in which it is maintained, if it is either created by the agency or acquired by the agency in connection with its business, with its mission, is going to qualify as a public record. Now, just because something is a public record does not mean it is disclosable under the Act. It just means it is a record that is subject to the Act's provisions as a whole. So this is a key definition that crops up over and over again. In our information age, replete with ever-changing technology, it's become increasingly important to really become conversant in the types of data and electronic records that would count as public records and that can be requested. The Act refers to records maintained in databases as records that may be requested in searchable and analyzable format. And generally speaking, these are going to be subject to the Act. They're going to be subject to the Act, and they are going to be disclosable if available in that form. The requester asked for it in that form, and it is feasible for the agency to provide it while at the same time protecting any confidential information. So that's several ingredients wrapped into one, all wrapped into 4205C. Importantly, under the Act, extracting data from a database or limiting the production of data to certain data fields is not going to constitute necessarily the creation of a new record such that the agency would not be under an obligation to produce it if they have it and can produce it without revealing confidential information. So let me just try to restate that a little more simply. Once upon a time, much earlier in our technology age, there was a thought that if you ask for certain limited data sets to be extracted from a database, that would constitute asking the agency to, in effect, create a new record. That particular question has gone up through the Maryland courts, and at least on the facts of the case considered, which is Emanuel versus Comptroller, many of you may be familiar with that case. Upon those facts, the court determined that it did not constitute the creation of a new record. And the principal reason was because the agency in question, namely the Comptroller's Office, was able to extract the data that was requested using its ordinary functionality. That is, it didn't have to hire consultants, it didn't have to reprogram its systems, didn't have to go out and buy new software. It had the means through its ordinary, using its ordinary functional capacities to produce the data. And then the court said in that circumstance, the extraction of the data is not creating a new record. It is requesting public records that the agency has to respond to. Okay. The Act refers to, on the agency side, the responsibilities of custodians. So agencies and their staff are custodians of public records, not owners per se. They are custodians of them. The official custodian is the person within an agency that has the official legal responsibility for compliance with the Public Information Act, for keeping the records and for responding to requests in a lawful fashion. In addition to an official custodian, there are many individual custodians of records, typically within an agency, and that would include anyone who has authorized access or physical control of the record. So as I have sometimes pointed out in other trainings, this means that quite often there will be multiple custodians within the same agency and across different agencies of the same record. So an agency staff can be and often will be a custodian of a public record, even though, for example, that person is not the author of the record, or that their own agency did not create it in the first instance. If they have it and are authorized to have it, and they are maintaining it in accordance with their public functions, then they have physical custody and control and are a custodian in the sense that the PIA intends. In the lower right corner, you'll see the little PIA manual icon with a reference to Appendix J of the manual. Appendix J is a listing of official PIA contacts for agencies throughout the state, both state and local agencies. And every agency is asked to, is directed by the Act to provide the Office of the Attorney General with their official PIA contact and to maintain that on their website. And that information is compiled by the Office of the Attorney General in Appendix J to the manual. So sometimes when we get inquiries from requesters as to whom a request should be directed, we will go directly to Appendix J. If we don't know off the top of our heads, we'll go to Appendix J and see who is listed. We also often refer to Appendix J as a very useful resource for making sure that your request, if you are the requester, goes to the right place and the right person. So it's a very important tool for agencies. We urge you to keep your listing up to date. It's one of the kind of very simple things agencies can do to make the PIA process easier and faster and less frustrating for the public. Okay, so this kind of is a summation of the requirements of Section 4503 relating to agency representatives, which I think I have covered in detail. At the bottom of this slide, to submit a change to or add a designee or to the official list, you can use the mailbox listed at the bottom of the page, PIA OpenGov at OAG, etc. And Spencer updates that list, I believe, on a monthly basis. So we do our best to keep that up to date. Okay, another term of art that appears in the Act is person in interest. And this phrase often comes up in the context of exemptions where a person's status as a person in interest, if they are one, may give them broader rights of access than are held by the public at large. So if you are making a request and you are a person in interest, it is very useful oftentimes to identify yourself as such. So in general, a person in interest is the person that a public record is about. And in certain circumstances, it can be the legal representative or the legal guardian, for example, of the person in interest. So generally, this is a status that gives broader rights of access, and if you are a person in interest, say so in your request, and it's something that an agency may need to inquire further about in determining how to dispose of a particular request. Okay, so with that background, what is a PIA request? It's really a very simple concept. It is any written request for records. Any written request for records. So this is consistent with the Act intent to be very user-friendly and mostly self-executing.
Nicole.
There are no special words.
Hey, Nicole, can you hear me?
Hi,
yes,
I can hear you. How are you?
I'm doing well. How about yourself?
Good.
Spence,
So for the stuff that you sent to me, you're good on everything right now?
I believe I am.
Okay.
So now might be a good time to ask folks if you're having other phone calls and doing other business right now, if you could mute yourself, that would be appreciated. Thank you. So the point of this slide is really to make it clear that anybody who sets out in writing that they want a particular record from an agency or a set of records from an agency, they have submitted a PIA request, regardless of whether or not the words PIA or Public Information Act appear anywhere in the request. We always recommend that when making a PIA request, that requesters designate it as such. It helps flag it for agencies who are the recipients. And we always, of course, recommend that when agencies have established procedures for receiving requests, that requesters use those procedures. It just helps in the processing of them. The PIA manual at Appendix A contains a sample PIA request. It's a sample only. It's not intended to be a Bible or anything like that. It's just an example of something that would count as a PIA request. Okay, so now this brings me to kind of the meat of what we're here to talk about today, which is not just how to make a PIA request, but how to make a good one. How to make one that is going to get you the records or information that you seek promptly and with the least amount of cost, and how to work with agencies to try to accomplish those goals. So what kind of tips do we have to offer? So the first, I guess, points I wanted to mention are there are some things that you should consider, or I would recommend considering before you fire off a PIA request. One is just kind of the general notion that while it is very easy to submit a PIA request, indeed, I mean, you can sit at home in your pajamas these days and fire off probably 50 requests in an hour, right? It's easy to do. It's not always so easy to answer them. And that is because the Act requires gives agencies specific timeframes for responding. It requires certain information to be provided in each response. It has provisions relating to having to estimate fees and give timely advice of those fee estimates, and in some cases to do this within very small agencies that may have limited resources, or very large agencies that have many departments and many different individuals that may have to be consulted. So it's always a good thing to consider to whom your request is being directed, and to take into account your knowledge of that agency or things you can find out about it even before you make a request. We always encourage agencies and requesters to talk to each other whenever possible. Whenever there's a question, an ambiguity, or some special problem or challenge that can be anticipated, Although the PIA deals with written requests for records and written responses to those requests for records, there is nothing in the Act, nothing whatsoever that prevents people from picking up the phone and asking a question, or picking up the phone and trying to clarify something before it gets to be a problem. And this can be very, very helpful, very useful. So I encourage both requesters and agency representatives to always take that into consideration. And if in doubt, you may want to consider picking up the phone. Okay. So on the requester side, I mentioned that our technology now makes it possible to fire off Public Information Act requests, kind of rapid fire. To do it, 24/7, any time of the day or night, 7 days a week, holidays, weekends, whatever. It's, our technology has given us that type of reach. But that is not necessarily going to yield the best results for you. And so I think it always behooves someone to do a little bit of homework and give a little bit of forethought to think about what it is what records they actually want, or if they don't know specifically what record they want, what types of records do you think would be most useful? To investigate, to the extent you can, what records the agency has, to make sure you're directing your request to the appropriate agency. Give some thought to what format these records are likely to be in. That could affect the scope of your request. And some of the tools that are now available to do this kind of homework include an agency's website, and of course, information that's available online generally. Many agencies will publish the process they use to receive Public Information Act requests. They publish information on their website about what they do. They may have information about their organizational structure. They may have information about the actual persons who hold key positions or head departments within an agency, and in general, information that will allow you to structure and inform your request in a way such that you're likely to get what you're actually looking for. If you don't know to whom or what entity your request should be directed to, one avenue is just to do some internet research to try to help you narrow the field. You can, if you don't know the appropriate custodian or representative, you can always consult Appendix J. As I mentioned, you shouldn't hesitate to pick up the phone and see if you can get some information from the agency. And if these avenues are not working for you or not yielding the information you want, you should feel free to reach out to my office. And we will our contact information is published at the end of this slide deck. But there are a lot of resources out there that can help inform you structure a request in such a way that you're more likely to get what you're actually looking for, to get it more promptly, and to get it with little or no fees. Okay, and one of the tools, I guess, that's available in terms of, would fall in the category of doing your homework, is to consult an agency's policy of proactive disclosure. Since July 1 of last year, there has been a provision in the PIA that requires agencies to publish a policy of proactive disclosure. And proactive disclosure really is just a fancy way of saying you must have a policy in place that describes those records that you will make available to the public without anyone even asking for them. And so to the extent records are available in that form to you, there's no need to make a Public Information Act request. They're already published. If you want to see examples of such policies, both my office and the PIA Compliance Board have adopted policies of proactive disclosure. They're published on our websites. And hopefully by this time, many other agencies have done the same. I generally say to agencies, the more thoroughly you embrace this approach. The more expansive your policy of proactive disclosure, you will, to that extent, lessen the burden of answering discrete PIA requests for material that you know is disclosable and that can be readily disclosed on a proactive basis. Okay, framing the request. By the way, I think Spencer mentioned we welcome questions at any time. So if any questions come to mind as we're going through this, please feel free, to either mention it in the chat or to unmute yourself and speak up. Framing the request is really maybe kind of the centerpiece of this presentation, because as mentioned, a PIA request is a written request for records. When you submit a written request for records, the agency is then bound to answer your request as it is written. So it will be engaged in trying to respond to the request as it is written, not as you later decide you may have meant it to be written or wished it was written. So putting some thought into how you are framing the request, doing that up front, can help eliminate problems and issues that can come about just because of loose language or the failure to make something clear or precise. Is the agency permitted to charge a nominal fee for records production under the 2-hour guidance? So we are going to talk about fees more particularly. Sarah's going to delve into the requirements related to fees. In general, though, actually, it's limited to actual costs and labor above 2 hours. But let me defer that question to Sarah's part of this. So some things to think about when framing the request. I mean, these are points that I've really derived from things that come up in my caseload that I see over and over again. And if I had the power to rewrite a request, I would be thinking along these lines. I find myself saying to myself, I would be thinking along these lines. Sometimes less is more. Keeping a request as simple and specific as possible can bring great benefits. In making a request, you do not need to give a very long narrative explanation about why you want the request and why you want the records and why it's important to you. I mean, you can do that, but it's not necessary, and sometimes it can confuse the issue. It can tend to bury what it is you are actually seeking. So think in terms of submitting simple, straightforward requests that are as precise as you can get them to be, bearing in mind that there is no limit on the number of PIA requests that a person can make. So this is, for example, fundamentally unlike what's known in the discovery process in court cases as request for production of records. In those settings, at least when I was in practice, there was a limit on the number of requests you could make for production of records. It used to be 30. I don't know if it still is. But, lawyers would think to themselves, oh, I've got to get it all. I've got to get everything I want in 30 requests. That's not the case with the PIA, not at all. You can take it step by step. You can break it down and say, I want record A. Wait till you get record A, read it. And it may suggest to you that you want record B, or it may take you in a different direction. Now I want record X. So think in terms of small bites, potentially being more useful and more effective than trying to swallow the whole apple all at once. Be direct, don't dance around what you're seeking, just state straightforwardly what it is you are looking for, or do it as best you can, even if you don't know exactly what records the agency may have. It's frequently very useful, even imperative, to give the agency some parameters around what you're looking for. When you can't identify a specific document that you want, try your best to provide search parameters for the agency so they know what they are looking for. So the use of specific timeframes, it can be very important. Specifying topics or search terms can be very important. And be careful, this is my suggestion, be very careful when you use the word all. Remember that agencies are bound to respond to what you ask for in writing. If you say you want all of everything, then they have to go look for all of that thing, all of it. And that can take time and that can add costs, and it may mean you end up getting a lot of material that you don't really want. It wasn't what you were looking for. So be careful with that. Again, I highly recommend people talking to each other whenever possible to try to get a better handle on what records the agency has, what records will be useful for their particular purpose, how to ask for them, and what to expect once that takes place. So I would put triple asterisks by framing the request and suggest that putting in the time and thought on that aspect can really pay very significant dividends for you. So when you set out general, I mean, there's no magic formula for making a PIA request. They are as different as all of the purposes and questions that members of the public may have for an agency. But some general considerations to think about as you are thinking about what to ask for and from whom to ask. Ask yourself as a threshold matter, is my first step really going to be using the Public Information Act? Is that going to be my most effective route to obtain the information that is of interest to me? Sometimes it is, sometimes it isn't. But you should, the PIA is not intended to rule out other avenues for gaining information. What factors should you consider when making a particular request? So think in terms of framing it, think in terms of parameters, think in terms of doing the research about what the agency may hold, what their actual work entails. And then think about what should be included in your request, bearing in mind that you don't have to get everything all at once. And in fact, oftentimes you may not be in a position to know what that all is until you get a little deeper into the subject area. So think about how you could logically and most usefully proceed to try to obtain the full picture of what you're looking for. Okay, avoiding pitfalls and reducing costs. Some of this is going to seem very commonsensical to you. Some of it may not be so obvious. Again, I would triple underscore this. Be careful when using the word all. If you say all, you should really do that very with an intentionality that you want everything. And if you make that request, you should understand that everything may encompass a broader search. It may take longer to complete, and it may entail fees, depending on what all is involved. Think about what is most important to you in your quest for information. What is the record or type of record that would be most useful? Is there a time frame that a narrower time frame you can identify that you can hone in on that is likely to give you the critical information, or at a minimum useful information from which you can then build upon? Understand the party who is receiving your request. Understand what they do, how they're organized, how they're staffed, to the extent you have the ability to know what are their limitations. A good rule of thumb to remember is that the Public Information Act, when it was written in 1970, was written with the intent that it should be very user-friendly, very efficient, very accessible, and non-adversarial. By and large, and for the most part, it is intended to be self-executing and non-adversarial. Therefore, it doesn't work quite as well, in my view. It doesn't work quite as well when it is used for other purposes. So there may be better and more efficient routes to obtain some types of information or to address certain kinds of underlying problems. But these are all things to consider if you want to keep your costs down and if you want to avoid certain types of potential problems. More on avoiding pitfalls and reducing costs. One of the tools that you can, when you're framing a request, that you can consider using to try to eliminate certain time requirements and getting things that you don't really need or want, is to expressly exclude those things from your request. So, for example, and I've often made this suggestion to folks when, for example, when communications are requested from various parties or communications on a certain topic are requested, I will often suggest to somebody that they consider specifically and expressly excluding from their request any communication that is to or from them, so that they're not requiring the agency to produce records to them they already have. And also to consider specifically excluding things that you know the agency they either can't produce, or at a minimum they're going to have to confer further to determine whether they can produce them or not. So a very common example would be a communication between someone within an agency and the agency's attorney about a subject matter that the attorney represents the agency on. So those types of communications are ordinarily subject to the attorney-client privilege. And when your request, as framed, calls up those communications, it is automatically triggering a need for greater scrutiny. Greater scrutiny means somebody has to sit there and read it. And it may go into a pile, no, we can't produce it, or no, it may go into a pile where you have to look at what to redact. Either way, it's slowing the process down, it's requiring more labor and potentially more cost to you. So always consider, when structuring a request, are there things that I know I don't want, or that I don't want to have to deal with right now, I don't want to pay for them right now. Let's put them aside. Let's exclude them from the request. Again, you can always come back with a follow-up request if the information you obtain leads you there. Exemptions occur, the bulk of the text of the PIA is really devoted to exemptions. There are a lot of them. Some are mandatory, some are discretionary. Some are focused on specific topics. Sarah's going to take us through that, but having some familiarity with the types of exemptions that are out there will help you frame requests that are less likely to require the more intensive scrutiny, or that are going to generate, even a blanket denial, because it's framed in such a way that it seems to call for only those records that cannot be disclosed. Some common examples where these exemptions can come up involve requests going to school systems, or to universities for that matter, where it is information about specific students are being requested. Requests going to law enforcement agencies, and there are different types of law enforcement agencies, but requests going to those types of agencies that seek investigative records, or information related to investigations can trigger exemptions. Medical records are generally off limits, and there are any number of agencies across the state that may well hold those kinds of records. So those are just a few examples of privacy and security concerns that have led to the adoption of specific exemptions. And when those exemptions come up against your request, they slow it down and they make it more expensive, and are more likely to generate a response that the requester is not going to like. Okay. So this takes us, Sarah, to your to your section here. I don't know if there are any questions, or if you want to dive into this. I'm not seeing any questions so far. Okay, I guess I'll turn it over to you.
Okay, sounds good. So as Lisa, I apologize for my voice. It's a little rough, but hopefully we can get through it. So as Lisa had said earlier, the PIA is really a sort of pro-disclosure statute. It's in favor of disclosure of public records. But there are a good number of exemptions within the PIA and also found in other sources of law that either require a record to be withheld or provide an agency with discretion to withhold it if certain circumstances are present. And so we're going to just go through very broadly what some of those kind of categories are. This isn't really meant to dive deeply into any one exemption, but just to give you a sort of a general sense of what sorts of records may be exempt and under what circumstances they might be exempt. So the PIA divides the exemptions into 5 different parts. The first one contains mandatory, meaning the record or the information has to be withheld and it's due to law outside of the PIA. Part 2 contains mandatory exemptions for specific records. So these are entire records that would be non-disclosable. Part 3 contains mandatory exemptions for specific information. So it may be that the record itself is disclosable, but there might be information in that record that would have to be redacted. Part 4 provides exemptions where a custodian has discretion. So the record is disclosable, but this custodian has discretion not to disclose it if disclosure would be contrary to the public interest, which we'll talk about in a little more detail. And then part 5 is really, it's one provision that allows a custodian to seek a court order preventing disclosure. So this is used it's not a super commonly invoked exemption, but it's used for those instances where the record or the information, nothing else in the PIA or outside of the PIA would allow or require withholding it, but the custodian has some pretty serious concerns that releasing the record or the information would cause substantial injury to the public interest is the standard. So what the process is the custodian would issue a temporary denial of the record, and then within 10 working days would have to go seek a court order to continue withholding it and basically get a court to give the custodian permission to continue to withhold that record. Okay, so part 1 is mandatory exemptions concerning law outside of the PIA. So and that's 4-301. A really common one that we see here has to do with the attorney-client privilege. So it encompasses common law privileges, the attorney-client privilege probably being the most commonly invoked. Those are for communications between an attorney and a client about the subject of their representation. If a record contains those communications or is entirely, of those communications, a custodian cannot release the record unless the client has waived the privilege. Other common law privileges that are less commonly invoked include the legislative privilege, executive privilege, and grand jury privilege. This provision also encompasses state statutes that might prevent disclosure. So juvenile records, there's a provision in the Courts and Judicial Proceedings article that protects certain police records about juveniles. There's a provision in the tax general article that keeps tax information confidential. So there can be, and the PIA defers to those state statutes. The PIA also defers to federal statutes and regulations that are promulgated under those statutes. A very common one that we see is HIPAA. There's also FERPA, which relates to certain education records and student records, are 2 common federal statutes that come into play under the PIA. And then court rules and orders. The PIA also defers to those as well. If you want to go to the next slide. So this is part 2. Again, this is mandatory exemptions for specific records. And so this is a list of some of the exemptions found in part 2. It's not all of them. I think probably of this list, the most common one that we see is the personnel records, 4-311. So if what you are requesting is a personnel record, it's a record related to an employee's ability to perform their job. Personnel reviews, performance ratings, things of that nature. Information that the person may have submitted in an application for a job, like a transcript or something like that, that would be off limits. A custodian is not permitted to release that information. And then you can see there's other instances of entire records, traffic citations and charging documents when requested by attorneys, arrest warrants and criminal charging documents before they're served on the defendant, MVA records, firearm, handgun records, security system information, and then distribution lists are just a sort of handful of the specific exemptions for records. And then part 3 contains mandatory exemptions for specific information. So again, this would be information that may be contained in a record that is otherwise disclosable. You may have, for instance, a police report that contains medical or psychological information. So that police report would generally be disclosable, but any information that must be exempt would have to be redacted. So medical information in a police report would have to be redacted. Sociological information, if the official custodian has adopted rules or regulations that define what that is. The home address or telephone number of public employees would have to be redacted. Another fairly common one is the trade secrets, confidential, commercial, or financial information that may be contained within a record. So you see this often when people are requesting procurement-related records from various agencies. There may be some confidential information in there that would have to be redacted. The personal financial information of an individual. So you have a record that might have information about financial transactions, involving individuals that would have to be redacted. Importantly, the salary of a public employee is not exempt under this exemption. So that is public information that is disclosable that a custodian would have to disclose in response to a request for that information. And then there's alarm and security information, and then infrastructure. So this was an exemption that was added in response to the to 9/11, and it protects sort of infrastructure, emergency response types of information in records. Part 4 is the discretionary exemptions. And again, so this is records and information that are disclosable, but nothing in the law requires that they be withheld. But the PIA does give a custodian discretion to withhold it if the custodian determines that disclosure would be contrary to the public interest. And that, the custodian would have to sort of take care to really consider and weigh the benefits of disclosure versus withholding, and make a meaningful and informed decision about whether or not to disclose the record. So subject to this type of an exemption, we have the interagency or intra-agency letters or memoranda, which is sort of a mouthful. That exemption is sort of more commonly referred to as for the deliberative process privilege. So this is information or records that reflects sort of like the advice giving back and forth between agency employees and maybe supervisors about a particular choice or decision that an agency has to make. If disclosure of that information would harm the decision-making process or be contrary to the public interest in that way, then the custodian withhold that information. Another common one on the list here that we see often is the records of investigation of law enforcement agencies. Those can be withheld under the discretionary exemption if disclosure would be contrary to the public interest. Also encompassed within that exemption now too are police misconduct records. So the internal affairs records before 2021, those were considered personnel records, so they were just off limits. The custodian could not release them. Now those types of records are subject to a discretionary exemption, so they're disclosable. The sort of presumption is in favor of disclosure unless the custodian determines and explains why disclosure would be contrary to the public interest. And so this past session, this is just sort of a brief update from the 2023 legislative session. There were a number of PIA related bills that were introduced, but most of them didn't ultimately get enacted. But House Bill 636 did. It's a pretty minor change, all things considered. It basically just sort of updated the PIA to include personal email addresses within the definition of personal information. Before, it just spoke to sort of physical addresses and telephone numbers, but now it directs, with the inclusion of email addresses in certain circumstances, custodians have to withhold personal email addresses from disclosure as well. All right, so now we can move to talking about fees. So the PIA lets an agency charge a reasonable fee, and that is defined specifically as a fee that bears a reasonable relationship to the recovery of actual costs incurred by the agency. And so that's sort of the key word is actual costs. I think there's an Attorney General opinion that talks about how the goal is that the agency will neither make a profit nor bear a loss in responding to a PIA request. So you always want to be focused on what it's actually costing the agency to respond. Those actual costs that are recoverable include the search and review time. So that would be at the hourly rate of the actual employee who works on the response, does not include benefits, and at the amount of time that it takes them to work on the response. An agency does have to provide the first 2 hours of labor for free. So if it takes less than 2 hours to respond to a PIA request, the agency cannot charge for labor. And an agency can charge for copies. So the actual cost of producing either the hard copies or producing the USB drive or the disk that the records are put on. And that limit, the agency, as I understand it, the agency can charge the cost of copying regardless of how long it takes to respond to a request. So if you have a request and it takes an hour to fulfill, the agency can't charge for labor, but it can charge, 15 cents or 20 cents a copy that it incurs to provide those copies. Sort of important things to remember about fees is that they can be perceived as a means to block or discourage a PIA request. Again, sometimes there's sort of a disconnect between a requester's understanding of what responding to the request is going to require, both in terms of, how their records are kept or what kind of review will need to be done. So, an agency may quote, a $2,000 fee in good faith, but that can sometimes be perceived by the requester, if it's not really explained to them exactly why the fee is so high, as just the agency trying to kind of block their or discourage their request. And always remember that if issues do arise around fees, and sort of trying to talk between the assistance from the ombudsman to try to work it out. And I'd also just note that, so the PIA Compliance Board has been around since 2016, and prior to July of 2022, their jurisdiction was solely focused on fees. So there are a number of Compliance Board decisions posted on the OAG's website that address various issues that arise in relation to fees. So sometimes that can be a good resource too. All right, fee waivers. This is another issue that crops up fairly often. So there are sort of two independent grounds that a custodian may waive a fee. And it is a discretionary call. There's no requirement that a custodian waive a fee, but they may waive a fee on grounds of either public interest or indigence. So for public interest fee waivers, the agency would determine that it would be in the public interest to waive the fee, to not require the requester to pay the fee. And an agency has to consider the ability of the requester to pay the fee and other relevant factors. There hasn't been a whole lot of guidance as to what those factors are. There is a case that we expect to come from the Supreme Court of Maryland by the end of the summer that may provide some more information about what those factors are. But just keep in mind, if you're a custodian and you get presented with a request for a public interest fee waiver, you can't just say, well, I think they can pay for it, so I'm going to deny it. Otherwise, that could potentially get reversed. And then on the flip side, for requesters, it's important to be really specific about why your request is in the public interest, and not to just sort of simply hang your hat on those two words alone. If you are a news blogger or a reporter, right? It could be in the public interest because you have the ability to sort of disseminate information about the records to the public at large. Or perhaps your request concerns an issue that has been of high interest to the public, and you have plans to use it in such a way that could kind of contribute to the conversation. So as to the extent that you can really articulate and explain why it's in the public interest, and why for the agency to bear the cost and not have you pay for it, can be to your benefit. The other thing I would just say to you with public interest, it doesn't, or actually any waiver, it doesn't have to be all or nothing. Sometimes, an agency may have the ability to waive half of the fee or a portion of the fee. So always consider that as well. The other grounds for a fee waiver are indigence. So this is only when the requester is an individual. An organization cannot qualify for a fee waiver based on indigence. The requester has to be indigent as defined by the PIA, and it's with reference to the Federal Register. And the requester has to submit an affidavit of indigence, which I believe the PIA Manual Appendix D has that a sample affidavit that you can submit. And again, even in terms of indigence, it is within the custodian's discretion as to whether or not to grant the waiver. And again, if you can't grant a full waiver, maybe consider even a partial waiver could be helpful. And then finally, timeliness. Section 4203 provides kind of the general timelines that custodians have to follow in responding to PIA requests. Generally, you're supposed to respond promptly, though the PIA does provide 30 calendar days in which to respond. But if you get a request that you can fulfill easily, you shouldn't wait until day 28 to do it. You should do it as soon as you can. 4203D does provide extensions. If the requester consents, the custodian can have it an additional 30 days for a total of 60 days to respond to a PI request. And then 4203B2 is what's commonly referred to as the 10-day letter. So if you have a request and you look at it and a custodian determines that it's going to take more than 10 business days to respond to it, the agency has to notify the requester in writing of that fact, and then has to explain how much time is going to be necessary, why it's necessary, and also provide an estimate of the range of fees that might be involved in responding. So, as soon as you receive a request, it's a good idea to kind of take a look at it and try to evaluate how quickly you think you can turn it around. If it's something that's very broad and looks like it's going to involve a lot of work, again, as Lisa said earlier, it may be a good idea to pick up the phone and call the requester or try to contact the requester sort of almost informally to try to maybe narrow the request or explain kind of what the problem is. But those are the sort of general timelines that govern PIA requests. And I think, Lisa, this is back to you.
Right. This brings us back to the do's and don'ts. So I have we have a few kind of takeaways for both requesters and agencies. Things just to keep in mind for requesters. Try to keep your requests simple and straightforward. Things will go much more smoothly if you do. Make your requests specific and precise as possible. Again, it will make for speedier responses, reduce costs, and quite often lead to a more satisfactory outcome. Treat people as you want to be treated. Always be polite and respectful. This is kind of the golden rule aspect. Identify your request as a PIA request. You don't have to do that, but it can help. It can help flag for an agency staff that this is to be a request to be handled under the statute. And if, to the extent you're able, always recommend following the agency procedures for submitting requests if they have them. So the flip side of all this is don't make your requests unnecessarily complicated or convoluted. Don't use vague and imprecise language to the extent you have some alternatives to be more precise. Don't be inconsiderate or antagonistic. That almost never gets you anywhere. And be very straightforward about what you're asking for. Don't embed it in the middle of a lengthier piece of correspondence that may deal with other issues as well. And then the flip side of this is for the agencies, and it won't come as any surprise. I always recommend communicating with the requester early and often. Whenever you're in doubt about what somebody is asking for, ask them. Don't guess, don't presume, ask them. If you anticipate there's going to be a fee, try to come up with the best estimate you can, give that estimate on a timely basis, and explain the basis for the estimate. It's not always going to be apparent to the requester why there are fees or on what basis some specific estimate has been reached. Treat people as you would like to be treated. Always follow the golden rule. Flip side of this, don't ignore requests if they come into you outside of your usual procedures and protocols. A PIA request does not have to say MPIA request to B1. A PIA request does not have to be submitted via specific agency forms or portals to B1. Don't ignore requests for a fee waiver. Give it consideration. Bear in mind, particularly when people are offering indigence as a ground, that if it's not granted, quite often the fees will be a barrier. It will prevent obtaining the records. Always follow the golden rule. And last but not least, just a few updates from my office about what we are up to. For those who may not be aware, my office has come up with some additional proposed regulations that have to do with our case, basically with our case management system, in order to bring it into compliance with new requirements that were imposed by House Bill 183. Those proposed new regulations are now published in the Maryland Register. You can access them by clicking on this link. You can access them on the Ombudsman website, and there will be a Twitter link going out shortly, which will also provide access. If you have comments about these proposed regulations, positive or negative, now is the time to give us those comments. I think we are open for comments until, is it August 14th, Sarah? I think it's August 14th.
Yes, it's August 14th.
Okay, so please, if you have comments, get them to us as soon as you can. We are planning another brown bag lunch training that is going to focus on the protection of personal information, what personal information is protected, what other protections come into play that reflect privacy interests, and the extent to which anonymizing data can be used as a tool to provide useful information without compromising personal information or privacy interests. We're guesstimating that that training will be offered sometime in November this year, so stay tuned for further announcements. Spencer's been hard at work working on the Ombudsman website. It's in process. We're hoping to make it much more user-friendly and useful to people. We're also working, my office will come out with its annual report that will reflect our first year of operations under House Bill 183. Historically, the PIA Compliance Board has invited the Ombudsman to submit this kind of report and attaches it to the board's annual report, which is required to be provided by, I think, October 1. So stay tuned for kind of a further analysis of the work we've been doing under House Bill 183. And then last but not least, the PIA CB annual board meeting is going to be happening soon. It will probably be in September of this year, but there will be announcements going out about that annual meeting. So stay tuned for these coming events. And if there are questions about anything we've covered today, we're available to respond. I think this may be the first time we have completed a training 20 minutes ahead of time. So we thought that there might be questions and discussion and wanted to leave time for that. But if there are none, we're happy to let you go on about your day. This is my contact information. This training will be posted to our YouTube channel. We regularly post announcements about the PIA via our Twitter account. Check out our website for additional resource material. And I look forward to the opportunity to work with you.
I saw that Avis put her hand up. So Avis, you can go ahead and chime in.
I just wanted to say thank you very much. It was a wonderful, really comprehensive presentation. And we're an agency. I've got two of my colleagues on here, and we were just discussing how much we learned. So thank you very much.
Oh, you're quite welcome. Glad it was useful.